This is not a how-to course about how to negotiate, but we're going to talk a little bit about what the labor law framework is for negotiations. That's the program today. And I wanted to start by just stepping back a little bit and not talk about negotiations first thing, but to just talk about the labor law framework overall. The National Labor Relations Act and our federal labor laws, very complex, can be very confusing, covers a wide range of topics, but I like to think about it as just a three-legged stool. So I just want to talk about the three underlying aspects or principles of the labor law that will, form part of the structure for the negotiation piece that we're going to talk about. And the labor law comes in sections, and the three pieces are Section 7, Section 8, and Section 9. I don't know, maybe some of you have heard the phrase Section 7 rights, because that's a jargon thing that does get talked about. The Section 7 right is the piece of the labor law that says that employees have the right to act together for their own benefit. They have the right to join unions, to form unions. Once they're in unions, they have the right to engage in lawful strikes and to act together for their own benefit. That's something that we take for granted as 21st century employees and trade unionists. But of course, back in 1935 when the law was passed, that was a radical change, because there wasn't a right to engage in concerted activity, and you might be enjoined or stopped by the courts from engaging in group activity because it would be found to be an antitrust violation. So the big change when the labor law was passed in 1935 was we had a right to act together. You couldn't be fired just for acting together for your own benefit. Once a group of employees decides to act together in the way of forming a union, the federal labor law in Section 9 says that the union that has been chosen by a majority of employees is the exclusive representative for all of the employees that are covered by the contract that's going to be negotiated. That means really only the union can speak authoritatively for them, and the union speaks for all of them. And we're going to talk a little bit more later about some of the implications of the union becoming the exclusive voice for the employees. And then what do you have? You've got the right to act, and you've chosen a union, and the union has the right to be the sole spokesperson for those actions. And then what? What's the substantive piece? The substantive piece is that the law says there's a duty to bargain, a duty to negotiate. And that's the whole underpinning. The duty to bargain is in two different sections of the labor law, and it simply says it's an unfair labor practice for either the union or the employer to refuse to bargain collectively with the representative of the other party. But what does that mean? First of all, what it sets up is a framework for the hope that the employer on the one hand and the union or the employees on the other hand are going to reach agreements with each other. Okay? And in order to make that happen, it imposes a couple of technical obligations on the union and on the employer. They're found in Section 8D of the Act, and what the statute says is that part of the duty to bargain includes the obligation to give a written notice to the other side if you have a contract and you desire to change it, or if you want to terminate it. So 60 days prior to the termination of the contract, or 60 days prior to the time that you want the change to be made in the contract, you're required to give a notice to the other side of your desire to do that, and then within another 30 days you have to tell the federal government that you've done it.
Is that irrelevant to its expiration? I mean, the contract has a date that it expires.
That's right.
If you don't send the letter, then the contract just remains in force no matter that it's expired?
It depends on the contract, and there are contracts that will say that if they'll give you a window for sending a notice for negotiations, and if you don't say within that window that you want a negotiation, it'll just turn over. It'll extend for another year. Other contracts don't have that language, so that'll be contract by contract. But if you're in a contract and you're looking to extend, renew, change, modify, normally what you need to do under the federal labor law is to send the 60-day notice to the other side. And if you don't do that, create a couple of particular problems for yourself, because one of the things about the 60-day notice is that you're forbidden from striking or engaging in any economic weapons within that notice period. That is to say, from 60 days from when you file the notice, you're prohibited from taking any economic action, and so is your employer. So that if you strike within that time period, you have two problems. One is it's not protected, Section 7 protected concerted activity, and striking employees can be fired without any protection from the Act. And it's also an independent, unfair labor practice. It's essentially a violation of the duty to bargain. And the result of that is if you go on strike within that 60-day notice period, the employer can run to the National Labor Relations Board, which will in turn run to federal court and get an injunction and stop the strike. So it's a technical requirement, but it's an important technical requirement. And for our purposes, just as we're talking today about the overall framework of the labor law, what is interesting about it and what the point of it is to you can see it's set up to create a structure for negotiations, for talking, a time frame in which the hope is, and what the labor policy is, that employer and union, employer and employees are going to reach agreements about how they're going to go forward, what the work rules are going to be, what the compensation is going to be, what the benefits are going to be. The whole aim is to push the private parties to reach agreements of their own. So that's sort of the technical piece, and now we know we have a time frame for it. But what is the duty to bargain? Technically speaking, it's the duty to meet at reasonable times, to confer in good faith about wages and hours and the terms and conditions of employment. That's all it is. So what doesn't that include? What's not on that list of what the duty to bargain is? No duty to agree. The duty to bargain absolutely does not require you to agree to any particular proposal, doesn't require any particular concession or counter proposals, and it's not a duty to reach an agreement. There's no federal labor law duty to actually get to the end of the day and to have an agreement. I mean, I'll tell you, the first contract that I bargained as a spokesperson for another group was long before I went to law school and long before I had any formal education about what all of this meant. And I made the same kind of mistake that a lot of orchestra committee members will make, or negotiating committee members will make in their first negotiation, which was to sit there and say, you're not bargaining in good faith because you're not making counter proposals. Well, it's not part of the duty to bargain. There's no actual obligation to make any specific counter proposal or to agree. So the framework is for the negotiations, but it's not only about negotiations. Obviously, the hope is that both sides are going to talk in good faith and reach an agreement, but each side also has other moves that they can make if the discussion gets too frustrating or isn't leading to an agreement. Right? So each side retains its economic weapons. The union has the right to strike. The employer has the right to lock employees out with certain restrictions. Okay, so on the right to strike, you can't strike if you're within the term of your contract and your contract has a no strike clause. Then obviously you can't strike until the contract has terminated or expired and your no strike clause has expired. And as I said before, you can't strike within the 60-day notice period. Same thing for an employer. Employer can't lock you out if you're in the term of a contract with a no strike, no lockout clause until after the expiration, and it also can't strike until the 60-day notice period is over. But once those restrictions are gone, you have these weapons in your pocket, but they're not required. They're optional, and it's also quite possible to reach the point where you have the right to strike, they have the right to lock you out, but negotiations are productive, or there's the hope that they're going to be productive, you earnestly want them to be productive, or you think your economic weapons in your particular circumstances are likely to be even less productive than the unproductive talks you're having. So you can also play and talk, or talk and work. But it's the choice that you have to make as you're trying to work your way toward an agreement. Another sort of important, if technical, piece about the duty to bargain is that it requires the employer to provide information to you, and the reverse is also true. It requires the union to provide information back to the employer if they ask for it. As a union side labor lawyer, I'm often finding myself being very cranky and saying it's the anti-labor law and railing about the harsh provisions within the labor law, or provisions in the labor law that are less than helpful to the union side. But there are these golden moments when you read board decisions or you read court decisions and you say, yes, they got it right this time. And one of the ways in which the courts and the board really have gotten it right is that they say, if the only duty is the duty to negotiate in good faith, not to get to an agreement, but just to talk, that has to be meaningful, and it won't be meaningful if both sides aren't dealing honestly with each other. Everybody's got to have the essential information for this negotiation process really to work, and everybody has to be speaking honestly for the negotiation process really to work the way we intend it to work. So that has led to the creation of the duty to provide information to the other side upon request. Now, the upon request part is important. The employer doesn't have an obligation to come and just hand you information that might be relevant to the discussion if you're not asking for it. So you need to be proactive about the information that you need to evaluate their proposals or construct your own proposals. Ask for it and make sure that you get it. Okay. So far we've talked about kind of what are the pieces of the duty to bargain, but when you get more to the heart of it, what is it really, and how is it breached or broken? Obviously, if part of the duty to bargain is, or part of the definition of the duty to bargain is the duty to meet, then if you refuse to meet, that's, you don't have to go a lot farther to, analyze that a refusal to meet is a refusal to bargain, and that's a breach of the duty. And similarly, if you ask for relevant information and the employer refuses to give it to you, they've breached the duty. So that's easy. That's a per se violation of the duty to bargain. But it gets a lot harder than that pretty quickly because of the problem that the duty to bargain does not mean a duty to agree. So how do you know whether the other side is bargaining in good faith, or what does it mean to bargain in good faith under the law? And that gets very hard to parse out or to figure out in a concrete situation, because the courts have said and the board has said that you can bargain real hard and that's still good faith bargaining, because there's no duty to agree. If there's no duty to agree, then obviously there's a total right to take a really tough position. I have to have these concessions. We'll fold if we don't get 26% reductions because we literally can't afford to go any farther. Or we have to change our health insurance, and thus in such a way because of the increases in the health cost, or whatever it is. You can be very adamant about your position and still be negotiating in good faith. So when all is said and done and you get down to kind of the bottom line, what the National Labor Relations Board has described as bargaining in good faith is kind of minimal. It's active participation in deliberations with a present desire to find a basis for an agreement. That is to say, the employer is within their rights and the union is within their rights if they do want an agreement. I mean, they intend to get to an agreement. They may intend only to get to the agreement that they want, But if they intend to get to an agreement, that's enough, and they can be as stubborn as the day is long.
Is there some hidden thing here where it says present desire? Does that mean like we desire it today? Am I reading too much into that?
No, I think you're not. I mean, I think that...
Have you ever encountered that where somebody would say, well, you know, at the time we said it, yeah, we wanted to agree, but now this is a month later and circumstances have changed, and so it's no longer our present desire?
I haven't had a case that turned on the word present, but it's not an empty word either.
Okay.
I mean, the reverse can also be true. You can have an employer that has said some pretty shockingly bad things indicating that they really don't want to reach an agreement, but if they shape up later on and then start behaving in a different way, then you know the things they said last year may not be very good evidence about what their present intention is. So if the lack of good faith is no real intention to reach an agreement, how do you show that to the board? And how it's the best thing you can possibly have to show the board that there isn't a good faith present intention to reach an agreement is an employer's statement that is to the contrary. We'll never agree. We will, and you look at me like that's impossible, but there are cases, and it does happen, especially with newly organized employers, where they say things that make very clear that we're not going to have a union in this factory, and then once they have the union, well, they got the union, but they're never going to get a deal. Yeah, so that kind of smoking gun is absolutely the best thing. That, of course, is not always going to be available to you. So short of having a smoking gun, how do you show that there's a lack of an intention to reach an agreement? Well, you know, if they've, I'll give you an example, and it wasn't my case, but it was a case in this office. It was an employer, was a newly organized employer, nothing to do with the music world. Fought the union every step of the way in the organizing process, lost an election, union came in. The union spent 4 solid months trying to set a date for the first negotiation. And it took that long to set the first date, including the employer at one point giving 3 dates to the union, and the union said, okay, we'll take all 3. And then all of a sudden the employer wasn't available any of those 3 dates. So 4 months to get to the first negotiation. During that 4 months, the information request is out there and hasn't been replied to. They get to the first meeting, and the employer representative picks a fight with the union representative, and they get into words, and the employer stands up and says, I don't have to speak to you if that's how you're going to talk to me. I'm not coming back here until you apologize. It stomps out and then refuses to meet. Oh, and also, when asked about setting dates, said, well, we can't do that right now because we don't have our calendars. And when the union representative said, so go get your calendars, we'll wait, they said, well, we don't need our calendars, our dates are in our heads. So we don't actually need our calendars. Then they picked this big fight and stomped out and said that they weren't going to meet until after there was an apology. And you know, another example, although it didn't happen in this case, is if an employer goes around and well, maybe not your employer, you guys have a decent employer, but a lot of our musicians have known the employers who sort of duck around the side of the union and try to reach deals with individual musicians. That kind of direct dealing also can be a kind of evidence. But what you have to do is you have to keep track of all this kind of stuff in order to make a case of no good faith or lack of good faith. You need to keep track of everything that's going on, document it, write letters that document it, and show an entire long course of conduct, because it's going to take all these little pieces to show bad faith. Not just stubbornness or being, hard-nosed about one position, but this kind of evidence that they're really not trying to reach an agreement with you. Another kind of example or way in which employers show a lack of good faith bargaining is what's called surface bargaining. That is, they're not refusing to meet, they're coming, they're sitting down with you at the table, but they're just kind of going through the motions. They're taking positions that were determined by their relationship with a different union or their relationship with another entity, so they don't have flexibility because they've already reached agreements elsewhere that commit them. They're completely inflexible. They send people to the table that don't really have authority. So if you hear too many times, we have to go back to the ED, or we have to go back to the board president. I mean, it's one thing to say we have to have the approval of our board. It's another thing for them to have people at the table who won't reach agreements in principle or reach the specifics without every step of the way saying we have to take a 3-hour break or we have to continue a different day because we don't know if we have authority to do this. Getting to the end and withdrawing provisions that have been agreed upon, or making significant, huge changes at the end also might be examples of surface bargaining. But again, you have to do what you would do in any other situation where you think maybe your employer is lacking in good faith. That is, you have to keep track of everything and document this whole course of behavior, because you're going to have to show, and you're going to have to convince a board agent or ultimately a court that you're by a whole course of conduct that the employer really was just playing a game with you and didn't want to reach an agreement. And keep in mind, all these duties are duties on the union too. So I've never known a union that didn't want to get a deal, but if you had a union that was being obstructive, the employer could make all these allegations back to you.
I'm sorry, it sounds like there's a really thin line between just being stubborn or hard bargaining and the surface bargaining.
You're exactly right. That's completely and exactly true. It's a very fine line, and that's the kind of thing that leads me as a labor lawyer sometimes to tear out my hair. Because, the labor law is supposed to be a law that governs the activity of lay actors. I mean, it's not all about lawyers talking to lawyers. It's supposed to be trade unionists and employers figuring this stuff out. And when the lines are that finely drawn and that technical, it's very hard for people to know how to behave. Well, but that's completely right. There is a fine line. So if there's no duty to agree and no duty to reach a contract, and you have the right to be stubborn about issues that are important to you, what happens if you've sat down in good faith, people have worked as hard as they can, and they get to a point where they're at impasse? That is to say, neither side can move anymore. What's the effect of that? Impasse is an important concept, and it has important effects. Okay? So you're at impasse, your contract has expired, you were playing and talking, you've gotten to a point where you can't budge anymore. The employer apparently can't budge anymore. He says can't budge anymore. So where are you? The employer has an important new right at that point. The employer has the right to impose unilaterally terms and conditions of employment that are consistent with the most recent proposals that it made to the union. Now, this is pretty dramatic because the whole structure has been a structure that makes the time for and puts the requirement on parties to sit down and try to reach consensus or a consensual agreement about how they're going to go forward. Now all of a sudden they've gone as far as they can go, they're stuck, and the law says, well, so much for all this agreement stuff. The employer actually can unilaterally impose terms and conditions of employment when you're at impasse. So this leads me to say impasse hands a huge weapon into the hands of the employer, and it is to be avoided for as long as you can. You really don't want to be at impasse. And we've all known people on committees, and I certainly have known people that I've worked with who like nothing more than for the spokesperson in negotiations to do a Nikita Khrushchev, take off their shoe and pound the table and say, no, absolutely not, we will never go there, and scream and yell and make a big dramatic show, and gets everybody very excited and, lets loose a lot of tension and makes you feel strong and dramatic. But what have you said? At the point where you're pounding the table with your shoe and you're screaming, no, never, never, we will never go there, my people will never do that. the employer says that's something we must have, you may be at impasse, handing them the right to impose. So you have to be a little bit more, what's the thing, dance like a butterfly, sting like a bee. You have to be a little more nimble in negotiations and try to avoid getting yourself locked in, at least before you're really sure that there's nowhere else that you can go. So it's wise and fruitful to spend your time at the table actually trying to analyze their positions and understand their positions, see where they're coming from, and look for maybe different ways to solve the problems that they've articulated, or different ways to define their problem. Figure out what it is they think their problem is and explain to them why it's really something else that's causing their problem, and maybe this other thing could solve it for them. Looking for solutions is not only appropriate because the structure is an attempt to reach an agreement. It's really supposed to be a dialogue in which you reach an agreement. But it's also good strategy because it keeps the balls in the air and keeps you from being locked into a situation where you can't go any farther, they can't go any farther, and you're at impasse. The duty to bargain, however, and information requests are another way to keep the ball in the air and keep the discussion going, because you're generally speaking not going to be at impasse if you've asked for relevant information about proposals, which is going to give you something to analyze and the possibility of breaking through to some other solution to the bargaining problems.
If they get to that point of impasse and they are going to impose, they have to impose their proposal in its entirety. They can pick and choose. I mean, if their proposal included some concessions to the union side along with major concessions that they were asking for.
Yeah, like everything else with labor law, it's, there's always going to be fine lines and a little bit hard to tell. The general rule is that they have to impose consistent with their last offer, and that would be kind of comprehensive, as opposed to cherry picking, just taking this onerous thing or that onerous thing and not giving you the benefit of concessions. But you can get into fights over, what they've done and whether they've imposed appropriately or not. The duty to bargain never completely goes away. It never completely disappears. But when you're at impasse, it is suspended, so to speak. You don't have to talk. They don't have to talk to you. You don't have to talk to them. When you're stuck and there's nothing to talk about, what happens though is you typically, anyway, you're only going to be at impasse for so long. Something's going to happen. They're going to impose. Well, all of a sudden the dynamic now is completely different. They've imposed conditions on you. That may cause the people in your bargaining unit to feel quite differently about the things that they were, locked and wedded to prior to that space and time. Your own side may be reevaluating what its priorities is and whether it's willing to move and how far it's willing to move. One side or the other may use an economic weapon. They may lock you out. You may strike. All of a sudden, that's going to change the dynamic, and they may become more flexible, or you may become more flexible.
They can lock you out after they've imposed a contract.
They could, yeah, they could. And the reverse is also true. People often think that you have to be at impasse before you can strike, or they can lock you out, and that's not true. Right. I mean, I don't know why anybody would. It's not necessarily very sensible, but
doesn't imposing the contract.
They're imposing conditions.
At least from their end.
It ends the impasse if it changes the dynamic and makes you more willing to reach an agreement. You could come in and say, we want to negotiate again. We think we have some moves we can make, and that brings you back to the table. Because the duty was only suspended, not eliminated. You're not stuck forever once they impose.
But once they've imposed, if you go back to the table, that imposition stays there. We don't say we're ready to talk now, so we go back to the old conditions.
No, I think the imposition is there, and so it's kind of sucks a lot of wind out of your sails. terms of bargaining. See what I mean about it being a big weapon? It's an important weapon. So when are parties at impasse? It's like just what we said before about when is party operating in good faith and when not. Is there a bright line rule? No. You have to look at all the factors and try to reach a judgment about whether or not these parties really are truly stuck. So factors are going to be how long have you been in negotiations, how many meetings have there been, are the issues that are left really the important ones, or are there a lot of little trivial ones? Because if there are a lot of little trivial ones, you're probably not really at impasse. You're just not working hard enough. What do the two parties actually understand about where they are, what they, how they've been proceeding, and whether they're really stuck or not stuck? And the other important factor is, has the negotiation really been in good faith? Because if one side or the other hasn't been operating in good faith, then you can't possibly be at a legitimate impasse. Okay. So we said the duty to bargain was the duty to meet at reasonable times, confer in good faith about wages, hours, and terms and conditions of employment. That last piece encompasses what's known as mandatory subjects of negotiation. The terms, wages, hours, and terms and conditions of employment are the mandatory subjects of negotiation that both sides are required to talk about. And essentially, that's very broad. Anything that affects your daily work life is going to be a mandatory subject of bargaining, pretty much. And if you're not certain whether or not it's a mandatory subject of bargaining, you sort of just assume it is until shown otherwise. Unless it's something you don't want to talk about and your employer does. And in particular, there are a couple things that are worth mentioning. There are also permissive subjects, that is, neither side is required to talk about them at the table, but it's perfectly lawful to do that if they're both willing to do it. And some permissive subjects are the definition of the bargaining unit and internal union affairs. These are ones where you may have to negotiate about them if you agree to, but you don't have to agree to do that. So, for example, if the employer wants to negotiate over whether librarians are in or out of the unit, and you have a long-standing unit, if you're happy with the status quo, you can refuse to bargain, and they can't force you to bargain over an issue of who's in, who's out of the unit. The flip side is internal union affairs. I have seen so many symphony orchestra contracts that have provisions in the contracts about internal union stuff, how the orchestra committee is going to be elected, how the players conference is, or the players committee is going to operate, things about union bylaws that govern the players committee. I don't know why that stuff is in collective bargaining agreements. There's no obligation to bargain with the employer over our internal union business. So be mindful of that when you're bargaining, and maybe seek some advice if the employer is asking you to bargain over what is fundamentally union business. The employer, on the other hand, doesn't have an obligation to bargain over certain things like what production methods are in the orchestra context, but essentially there's a bottom line at which the employer gets to run its business or decide to go out of business and doesn't have to bargain with the union about literally the methods. How they affect you, how they affect employees, has to be bargained, but their decisions about how they're going to operate don't necessarily have to be bargained. And there are some illegal subjects, but not very many. It would be illegal to sit down and negotiate a long, complicated provision that amounted to restricting hiring to union members or people of certain races or sexes or, sexual preferences or, whatever. You can't bargain over things that are illegal.
They can't agree to hire only union members?
No. They can't agree to hire only union members.
So how does a union shop
It is illegal to require union membership or non-membership as a condition of being hired. Okay, so it is, however, lawful for the employer and the union to agree to a contractual provision that requires a person, once they're hired, to meet certain obligations to the union. Okay, so, and we call those union security clauses. And they're the provisions that typically in contracts say within 30 days of being hired you have to join the union. Okay, they have been interpreted to mean not literally join the union, but within 30 days you have to either join the union or meet a financial obligation to the union. So the words may say one thing, but the enforcement really means something quite different, and that's lawful. And that's another one of those places in the labor law where, as cranky as I am, I look at it and I say, well, here's a place where even our Congress is anti-union as it can often be, and even our board and our courts as obstructive as they can often be, they really did understand, because the reason for the union security provisions being lawful is that the board and the courts looked and said, we've imposed a duty of fair representation on the union to represent everybody fairly and equally, but we're not requiring union membership as a condition of hire, and this may end up in a situation where the union has very strong and severe and important duties toward everybody in the unit, but isn't getting compensated adequately, or gets costs not being paid, because it can have free riders out there, people who don't join don't pay, and they're free riding on the efforts of the union. And that's not okay. That's a problem. So in order to solve that problem, we will allow these kind of union security provisions that require people and employees in unions, or in units, bargaining units that are represented by a union, to support the union either by joining or by paying their fair share of the fee. Okay. Another thing, just to, and we'll skip over this maybe a little bit quickly, another thing to keep in mind is that once the contract is in place, the duty to bargain never disappears. The duty to bargain is like the poor. We have it always with us, and it's just always there. That doesn't mean once you're in a contract term that either you, on the one hand, or the employer, on the other hand, can revisit things or force the other side to revisit things that were actually discussed and agreed upon in the contract. Once you've reached an agreement on a specific thing in the contract, that's good for the contract term, and it can't be reopened without agreement to reopen it. But contracts can never, even as long as some of them are, and orchestra contracts are some of the longest, are never going to cover everything that could happen during the term of the contract. It's just not possible to foresee everything. And if a new issue comes up, the employer's got a duty to bargain with the union about the new issue. It can't just unilaterally make changes on mandatory subjects of bargaining. It's got to come to you and make a proposal for what they want to do and bargain with the union about what it is and what it's going to be and what effect it's going to have on you. Now, in the middle of the contract, it has to be a change that's really going to affect a lot of people. I mean, important changes, not trivial changes about one person's assignment or a minor thing, but something that affects the bulk of people in the unit. Again, you have to ask for the negotiations, just like you have to ask for information. They have an obligation to give you notice, and if you just take the notice and don't say, okay, we want to sit down and have a negotiation with you about this, we need to discuss it, then you've waived your right if you don't do that. But if you make the demand for bargaining, then they are required to sit down and have that negotiation with you, and that's something to keep in mind during your contract terms. Same thing is going to be true of midterm negotiations, as is true of your regular negotiations at the end of the contract. That is, The duty to bargain is just the duty to bargain in good faith. It's not a duty to reach an agreement. So you can end up at impasse. And what happens at impasse? Same thing.
They get to impose.
They get to impose a change, exactly. So once again, you're probably going to want to work to keep the discussion going and keep the balls in the air. And information requests can be very helpful for keeping the issue open and also giving you sufficient information that you can really analyze what they think is going on, what the problem is, and maybe come up with different solutions that are acceptable to you, ways to compromise and do something you can live with and they can live with. But you want to try to keep the discussion going as long as you can and avoid impasse and avoid the imposition of that term that you don't want. So that's the basic, structure of the labor law requirements. How do we enforce them? The statutory structure creates a specific agency to enforce the labor law requirements, and that's the National Labor Relations Board. It's the board members are presidential appointees, so there is a political element, and we've all heard how boards can be more conservative or less conservative depending on who the presidents are who appointed them. There are 5 board members, and they obviously can't do all the work of the board. So the board is a big bureaucracy. It's divided into regions. Regions have regional directors and big staffs in order to process all the work of the board. And if you believe that the employer has committed an unfair labor practice, which is the technical term for violating something in the labor law, or conversely, if they think the union has, what you do is you file a charge with the region in which you're located, and it'll be investigated by the staff of that region, maybe a lawyer, may not be a lawyer, who will investigate it, sit down with the regional director in their weekly meetings. They will come to an analysis of whether they think it's likely that there's been a violation of the law. And if they think there's a violation of the law, then what the region does is issue a complaint. And the complaint goes to trial in front of a judge who's an administrative law judge. And the administrative law judge's decision ultimately can be reviewed by the board members in Washington. So it's a long, kind of tedious enforcement process, can be quite slow. Not in absolutely every situation, but in very, very many situations, it can be very slow. There's a 6-month statute of limitations, so if you're going to file a board charge, you have to do it within 6 months of the act that you're complaining about. That's an important thing to remember, because if you miss the deadline, you're just too late. And the other important thing to know is that in between the investigation of the charge and the issuance of a complaint, or the decision not to issue a complaint, always, the board agent who's investigating is going to come to the charging party and the charged party and give a preview of where they're at. We think there is merit to this and we are likely to issue a complaint, or we think there is no merit to this and we are not going to issue a complaint. And they'll give you a chance to back off. If they tell you they're not going to issue a complaint on it, they'll give you a chance to say, well, then I want to withdraw, rather than have it go to board trial where you may, well, the other way around, right? Oops. If you file the charge and they think it has no merit, they'll give you a chance to withdraw, so that you don't get a regional director's letter saying that there's no merit to your charge, and so you don't end up with something in writing. And if they do think there's merit to your charge, they will tell the employer on the other side, we're likely to issue a complaint. Our suggestion to you is that you reach a settlement with us right now to avoid going to trial on that issue. And they'll always try to find a way to resolve the issue short of a board trial. Okay. On the other hand, once you've gone through the negotiation and you have a contract, you have a collective bargaining agreement, that stands in a different place. The contract this is like the holy grail. This is what the whole process was designed to do, was to get you to a place where you have a contract that's a private agreement between the two parties, that in which you've reached a consensus on what terms and conditions are going to be. That contract is not enforced by the board. It's enforced by the system of grievance and arbitration, assuming you've agreed to grievance and arbitration in your contract. And I don't think I know of an orchestra contract anywhere that doesn't have grievance and arbitration. The idea of grievance and arbitration was to give a faster and less expensive dispute resolution mechanism than suing in court. So, your normal contract, a commercial contract, if you have a dispute under that contract, you have to sue in court. But if you have a dispute under a collective bargaining agreement, you can file a grievance, try to resolve the grievance. If you can't resolve the grievance, you can go to arbitration. I think that grievance and arbitration is not nearly as fast or as cheap as people envisioned back in the 60s when that system was created, but it's still a lot faster and a lot cheaper than suing. And then the last thing that we're going to talk about is the duty of fair representation. We said at the beginning that the duty was implied. It was an implied duty, by which I mean you can't read the statute anywhere and find the words duty of fair representation. But what happened is that the structure of the act, which gives the union the exclusive right to speak for everybody, led the courts to say, if the union has the exclusive right to speak for everybody, it must also have a duty to do it fairly, or you could have a really big problem. You have, one entity that can speak, and it can use that position in an unfair or abusive manner if it doesn't have a duty. So it's an implied duty, and the consequences, you can see the answer right up there, but I ask this all the time, who does the duty run to? Everybody in the bargaining unit or just the union members? It's got to be to everybody, right? If the whole reason for the duty is because the union has the right to speak for everybody, then they have to have a duty to treat everybody fairly and speak for them fairly. And that is a critically important thing to always remember. Who's got the duty? Well, again, because the duty comes from the right of the union to speak on behalf of everybody, it follows that the duty is the union's duty. The union is the entity that has the duty of fair representation, because the union is the Section 9 representative with authority to speak for everybody. But, what's the union? The union's an entity, it's an institution, it's a structure, but obviously the people who are acting for the union are individual humans. So, your union officers, obviously, when they come in and do negotiations, or when they come in and do grievance and arbitration, they have the duty, but they're not the only ones who act on behalf of the union. A lot of unions have union stewards, and musicians also, in some orchestras, have union stewards, and those stewards are acting as agents for the union, so they have the same duty to behave fairly in conformity with the duty of fair representation as the union president does. And in many orchestras, most orchestras, every orchestra maybe has an orchestra committee. Orchestra committees are sort of funny entities. They are also acting as agents of the union in very, very, very many of the things they do. When they negotiate, they're acting as agents of the union. When they investigate and resolve or try to resolve grievances, they're acting as agents of the union. Whenever they're doing union business, they're acting as agents of the union and also have the duty. Okay? That doesn't mean that there's any potential individual liability, but the obligation to conform your behavior to the duty falls on everybody who's doing the union's business. Okay? So what does it mean? What is this duty of fair representation? What does it amount to? It's an alarming thought if you think that it's the duty to be perfect and to never make a mistake, because that would be an incredibly high standard. And in fact, employees that sue unions for alleged breaches of the duty of fair representation most often lose their lawsuits because they think that the duty was a duty to be perfect, and they think that any mistakes made by the union amount to a breach of the duty of fair representation. Well, that's not the case, and that's, maybe the last one for today. Another one of the places where I can say the board and the courts got it right. They completely understand that it is impossible for any union to be perfect. There's no entity that will never make an error of judgment, make a mistake, misread kind of what the strategy ought to be, or come to a conclusion that in hindsight is not the best conclusion, but that looked reasonable at the time. So it's not a duty to be perfect, thank goodness, because that would be incredibly onerous. But it is a duty to behave in a way that's not arbitrary, not discriminatory, and not in bad faith. Okay, and that's all it is. I don't mean to minimize that. That's important. Those are important things. But it's that's a far cry from the duty to be absolutely 100% perfect and always be prescient and know what the future's going to bring and make the perfect judgment.
And in a grievance process, it doesn't mean that you can't at some point in the grievance process agree with the management's. You don't have to carry that person's grievance necessarily
to the Supreme Court.
Yeah. If you come to a reasonable conclusion that the management's position is a reasonable one.
That's absolutely 100% true, and it's an important thing to realize that on a whole bunch of different levels. I mean, what does it mean to not be arbitrary? Well, at bottom, doesn't it mean having a sensible reason for what you're doing? If you have a reason that makes sense for what you're doing, you're not behaving in an arbitrary way. Well, how do you get to a sensible reason for the decision you're making? You have to look at the facts. You have to know the facts. You have to take the time and put in the energy and the effort to find out the facts. So you investigate the grievance, find out what happened factually, and you investigate the contract. What are the words? What are all the words? Not just, look at half of a paragraph, but read the whole contract in context. How does it relate to the facts you know? And then reach a reasoned judgment. Is this, does this make sense? Is this a meritorious grievance? Was there really a breach of the contract or not? Come to a reason based on the facts and the contract, and then you're not being arbitrary. It also leads you to make a judgment, and the judgment sometimes is going to be that the grievance doesn't have any merit. And in that case, it's consistent with not being arbitrary and not being discriminatory and not being in bad faith to say, look, we can file this grievance, we can take it so far, but this is not a case that can go to arbitration because we're wrong and we risk losing, it's has no merit, and we aren't going to use up our credibility with the employer by pushing a point that doesn't have any merit and doesn't make any sense at the end of the day. It's important in the long term of your relationship with the employer to have your credibility. I mean, it's what you have. What do you have when you sit down across the table from the employer? You have, the people behind you, and you have your own credibility. And if you are constantly taking positions that make no sense or have no merit, then the employer is not, when you come to them and say, this is what it has to be, they're not going to believe you because you're full of beans, half the time. So it makes sense from a strategic and important point of view to not feel like you have to push everything, but only to push the things that you have a good reason for pushing. So we talked a little bit about how to avoid arbitrary conduct by investigating, by paying attention to your deadlines and your procedures, and actually inquiring, investigating the facts. Then you're not being arbitrary. Okay. And how do you avoid being discriminatory or behaving in bad faith? You don't make decisions based on somebody not being a member of the union. You don't make decisions based on somebody being your political enemy. You don't make decisions based on somebody being a pain in the neck. And you certainly don't make decisions, which can be, difficult maybe sometimes, right? And you don't make decisions based on race, sex, or any other impermissible category. You make all your decisions based on your investigation of the facts and your analysis of the contract. Real legitimate reasons for what you do. So Bill was right. He talked about the duty applying both to bargaining and to grievance processing. So you have the duty in both places. Again, this is a place where the courts get it right. They understand that when a union is in negotiations, it is not typically going to be possible to absolutely please everybody. It's in any bargaining unit, you're going to have people who are closer to retirement, people who are very young. Well, pension issues may be more important to the one group. Current paycheck may be important to the other group. You have people with more seniority and less seniority. People who need one thing, and for people for whom the opposite is really the more important thing. You can't make everybody perfectly happy all the time. It's not possible. But when you're bargaining, your obligation is to consider the needs of the whole unit and all of its different parts. Think about them, weigh them, and come to a sensible, non-discriminatory, good faith judgment about what's best for the whole. Okay, and go forward on that basis. And as long as you're doing that, you're bargaining within the duty, even though you haven't pleased everybody, because it's not possible to please everybody. Same thing with grievances. It's perfectly okay to drop grievances that don't have merit, as long as you have a valid reason for the things you do.
How much of a line is that? I mean, no merit is easy, but what if it has some merit, but maybe it's too close to call, or maybe you think that you've only got a 30% chance of winning?
Yeah,
Is
that's
that
hard.
something that you simply make a judgment and do your best and that's good enough? Is that fair representation?
If you making a reasoned judgment is good enough. Now that to meet the strictures of the duty, you obviously want to do more as a union representative than just meet the bare requirements of the duty of fair representation. You want to do a good job, and then it just kind of depends, and not every sort of case is different. Is the same. For instance, if you had a disciplinary termination case, you might have a pretty good idea that your chances of winning it are not that good, but it's incredibly important to that person. And if it's not going to make bad precedent that's going to hurt anybody else, it may be important just to go fight that one right to the end, even though you might lose. You just might have to do it. On the other hand, a contract interpretation issue that is got policy ramifications within your unit and also everywhere else. You might say, our chances of winning that one are very, very slim, and if we lose it, we're going to set a bad precedent that we don't want to live with going down the road. Well, that may be important to back off of that one. So judgments may be different depending on whether it's a contract interpretation, whether it's discipline, and what the specific facts are. There's never going to be just one easy, bright line answer. Never. There's never one easy, bright line answer.
But your duty is essentially just to do something reasonable and
Have to have valid
diligence.
reasons based on facts and based on the contract and based on the law. That's the duty. The consequences of a breach, if an employee, a member of the bargaining unit, thinks that or feels that you've breached the duty of representation, they have two possible routes they can go. They can file an unfair labor practice charge with the National Labor Relations Board, and it'll follow that whole process we described before. Or they can file a federal lawsuit. And that's a federal court case, and the old thing about making a federal case of it, that's what they do. They make a federal case of it. And as I said before, unions win most duty of fair representation cases brought against them, mostly because aggrieved individuals and their lawyers don't really understand the labor law and don't understand what the duty is. But, you can't really take very much comfort from the fact that you're likely to win a case if it's filed against you, because along the way to winning, what's going to happen? You're going to, especially if it's in court, if it's a case, you're going to have a lawyer, because you're not going to really very well be able to defend yourself in court without a lawyer. So you're going to be paying a lawyer. You have to file formal legal pleadings, like an answer to the complaint, answers to questions. You're going to have to ask questions of the other side in a formal written process. There are going to be depositions, which are sworn statements in front of a court reporter without the judge, but the obligation to tell the truth in a very formal setting, and that's expensive. There may be summary judgment motions, which are requests to the court to deny the lawsuit and throw it out of court short of a trial, and that's an expensive process. You're going to be spending oodles and oodles of money in order to win, and that's not very good for the union. And the other thing it's going to do within your community is be a destructive and unhappy and divisive force within the union, and that's not good for you either. It's not good within the orchestra, it's not good within the local to have a situation where you're fighting to defend your honor, and there are people who are accusing you of having done the wrong thing. So, for every reason, including it's just the right thing to do anyway, and it's expensive and divisive and destructive to defend against lawsuits. You want to try your very, very hardest always to behave in conformity with the duty and do the right thing. And union security, I think we've already talked about, and it's an hour. I mean, just about an hour. So I think
you covered everything you felt you need to.
Yeah, everything that was on the list of topics.
Yeah,
that's great.
There's one question that kept coming up as you were talking in my mind. If either side, say, does not bargain fairly, for example, what real remedies do you have? I mean, what happens when they're clearly,
they're not bargaining in good faith with you?
They're not showing up.
Yeah.
I mean, what really happens after that?
Yeah. Well, your technical rights under the labor law is to file an unfair labor practice charge with the board, and so you allege that they're violating Section 8A5 because they're not bargaining in good faith, and you provide that all the documentation, the laundry list of everything they've done to show this course of conduct that you hope is going to convince the board agent that they're not bargaining in good faith.
And if the board agent is convinced, then what happens? This is what it is.
Well, the board agent will, if the board agent's convinced, they will go to the employer and say, we are inclined to believe there's merit to this charge, and we're going to file a complaint against you. Would you like to sit down and find a way to settle this? And they'll try to get the employer to settle. Now, what does that mean? They're not going to. The board doesn't have the power to charge damages or do anything punitive. It'll be a settlement in which they submit to an order to go bargain in good faith.
So the worst that can happen is they can spend 9 months to a year being told to do what they weren't doing.
Yeah. No, the worst thing that can happen is that they say, oh, nuts to the board agent. They refuse to settle, and it goes to board trial. And then it'll be months of evidence as to whether or not they bargain in good faith. And then if they lose that, they appeal it to the board members, and then it'll be more months.
But ultimately, what happens if everybody agrees? Yeah, these guys, they're just not.
It's in order to bargain.
They're not even showing up to any meetings. They're telling us that we're not interested. The board, everybody agrees. What's the ultimate penalty at that point?
It's in order to bargain. It's in order to bargain, which is why it's important not to only think about the legal structure, and we have to know the legal structure, but the legal structure isn't the whole kettle of fish by a long shot in the struggle to get an agreement. And I think there are going to be other modules in the course that are going to be talking about public relations and other kinds of tactics, because although it might be important to file a board charge, the more important thing than the actual resolution of the board charge may be the press release that explains that you filed a board charge that has accused them of not bargaining in good faith, and the outreach to your board of directors in order to explain to them and get some support from your governing board, outreach to the community, and all that kind of publicity to try and. I mean, the whole effort has got to be to put the pressure on them to come back to the table and deal with you in good faith and push the dynamic in that direction. And the legal stick is sometimes kind of floppy, and the PR stick may be a harder, more firm stick that will get you there.
So there's ultimately no penalty for failure to bargain in good faith. They can only force you to do what you should have been doing all along.
And
Yeah.
then if you still don't do it then, I mean, there's no contempt of court that they can spend time in jail.
No, it would take they're so we get to edit this later, right? That's the good thing. If this was a live feed, I would be
Yes.
horrified. There are probably some cases that are so extreme that the board will impose a contract, but like there's so or certain provisions. There are, but it's not even worth thinking about because those would have to be so extreme and so particular that it's never anything that's going to happen to you. And that's definitely we're not putting that tape on.
What is the ultimate penalty is they can say, well, you've never bargained with these guys. We've ordered you to bargain, and you still just left town and not shown up. So this is now the contract you're working under, right? These are your obligations.
It's
It's
not
never
even worth
happened.
thinking
It's
about.
never
I mean,
happened.
it's probably happened, but it's not even worth thinking about because it takes such an extreme situation. Like the example I was when we were really taping before, the example that I was talking about was really an example of a case in this office where, they went at least twice to the board and got bargaining orders, at least twice. I mean, I think it may have even been 3 times that they filed unfair labor practice charges under 885 and got bargaining orders. The behavior was really egregious. They never got anywhere near a situation of the board being willing to force a contract. And the whole structure is the parties, setting up a structure for the parties to reach an agreement themselves. Although, I mean, we all know the situation where the town mayor comes in and sits with bargaining parties in the crucial night and puts incredible political pressure on them and forces them to reach an agreement. But that's sort of that's a kind of a local political kind of dynamic. It's completely outside the structure of the National Labor Relations Act. That's really just designed to force real private sector agreements between the individuals. It's a huge deal. The president will come in for a transportation strike, and will have the power to force in transportation or other kind of critical things. The president will come in and has the power to force agreements. But short of that, and just normal private sector stuff, that government isn't in the business of making people agree, only setting up the structure where they have to try.
Well, like even in that case, it sounds like it's almost more of a PR thing than an actual legal thing.
Mm-hmm.
But I got to go back to your very first point, in which you said this whole structure is set up, but you're not obliged to agree.
Mm-hmm. Mm-hmm.
And yet, all along, you've been talking about how to come to agreement.
Right.
But we're not obliged to agree.
Right.
Can you just talk about that a little bit? I think that's kind of
Weird.
yeah, weird. That's a good word. It's just totally weird. I thought the whole point. I mean, we hear this all the time in meetings. We have to agree to this, or what are we going to present to them? We have to be in agreement, or they've come out as. I mean, if the whole point of this whole thing. I mean, you have to agree.
Well.
Eventually you have to agree, right? Otherwise you have nothing.
Well,
and yet your definition says you're not compelled to agree.
That's exactly right. The consequence, because you have to agree not because the law requires you to reach an agreement, because the law doesn't require you to reach an agreement. But what's the consequence of not reaching an agreement? The consequences of not being able to reach an agreement are severe.
Yeah, you don't have a contract.
Employer may impose or you know, if you go long enough and you're completely unable to reach any agreement, your support of the troops behind you may crumble, and your whole unit may end up dissolving. You may end up actually losing the union, and because you have, you know, there's no there at your back anymore. It's, you know, very severe consequences to not agreeing.
For both sides.
For both sides, although it's easier for me to see them for the union side,
Yeah.
just by the nature of things. But it
But I mean, they want to have a factory that works, they want to have an organized place,
Right.
you know, I mean, that's why they.
that's right. They want to.
exist.
You see the results.
Exactly, they want to be a going operation, and you know, orchestra institutions, they want to have the love and respect of their communities. They're going to require. I mean, they depend on the communities for their financial support. So they can play hardball pretty far, but at a certain point, if they can't come to terms with the union, they're going to start pissing off and frustrating their local community and government structures and their donors. So there are pressures on them too to reach an agreement, and consequences if they don't. But you know, it's capitalism. The structure is the private parties. You know, it's a private party agreement, not government enforced.
Well, thank you.
Thank
This
you
has been
guys.
Terrific, and I just hope that they get a lot of use out of this, and that it's really a
Well, I hope so.
big hit. I don't know when this debuts. I
I don't know.
think they've got about 6 months of work to do before.
Well, and they're all. This is just one little.
This is one
piece,
piece. They
and
have some other. There's one taping I think that